to that forum, even in case of a modification, the court cannot do the modification.
No, just see 3G7 in Hakim Para 12.
Para 12, my lords. Just
There seems to be an expansion of the power of the arbitrator
3G, my lords, para 12.
in Hakim Para, page 13.
Section 3G, my lords.
3G,
3G.
subsection, see, first it goes to competent authority,
My
then
lord.
it goes to central government, then it goes to arbitration. Now, 6 says act will apply, 7, just read 7.
The competent authority or the arbitrator,
Or the arbitrator. Now read.
while determining the amount under subsection 1 or subsection 5, as the case may be, shall take into consideration the market value of the land on the date of publication of the notification. Under the...
That's a redetermination done like the reference code.
No, my lord, my submission over here is, my lord, the
Yeah,
arbitrator,
is understanding.
the competent authority or the arbitrator. My lord, when the matter goes to them, my lord, do not decide on the basis of the market value of the land and still passes an award. What is the recourse available against that? The only recourse as per the scheme of the act is section 34.
Post this stage, you are saying.
Post this stage, my lord. And we are also concerned with the post stage of the award. When the award is already there, be it passed by the competent authority under the NH Act or the arbitrator under the NH Act or under any other contractual matter relating to a constructor or a builder. When a stage of award has already passed and the matter has been decided one way or the other, now who is to then remedy it? So the Honorable Court, my lord, in this case, my lord, holds that you have to go back to the arbitrator because he is the person. But the cost element which is involved in all other private arbitration, including the institutional and the international commercial arbitration, re-invocation of the arbitration, my lord, that aspect has not been considered over here. Under the statutory arbitration, where the official is a government official bound by the official memorandums of the government, where the amount is fixed, not more than 10,000, 20,000 rupees in certain cases. The re-invocation of the arbitration, at least on the cost element, can be considered as not onerous to the parties, my lord. Here in the cases of the private arbitrations, when we have to go back, now arbitrators normally in all the matters, my lord, they don't normally give the actual cost incurred by the parties. What they give is the notional cost, even with regard to the fees also, my lord. When the parties go back for the arbitration, they have to incur the entire fees and the expenses with regard to the arbitrator, with regard to the lawyer's fee, and then wait for the final adjudication of that award also through the process of the court. That entire process, my lord, is a cost.
Already argued by Mr. Kumar and Mr. Datta.
No, that's what I'm not insisting on that point. I'm just simply referring to it in this context, my lord, that Hakim did not consider the aspect with regard to the cost element on the process of re-arbitration, my lord. That's what one point is, my lord. My lord, one judgment, my lord, which I cited in the compilation, my lord, the second compilation which I filed, my lord. It's the Alpine Housing Development, the second volume, my lord. Just briefly, my lord, with regard to the applicability of the provisions of the code, my lord. Though Mr. Khambata has argued on that, my lord, with regard to the inherent powers. And it was also indicated before this honorable court that the judgment in the ITI Siemens has been doubted by the division bench in the subsequent case. My lordship may kindly have this judgment of Alpine Housing Development. Division bench of the Karnataka High Court, my lord. Just a few passages. Page 81, my lords. The last 8 lines. It was in the context of the Consumer Protection Act and the applicability of the CPC over there. And the Honorable Division Bench says, a perusal of the lordship have it, not? Lordship have? A perusal of the entire Consumer Protection Act 1986 would disclose that the provisions of the Code of Civil Procedure 1908 have not been excluded. Generally speaking, the Code of Civil Procedure only codifies in one code what may generally be viewed as the general principles of law concerning the procedure which we are concerned to be handmaid to justice. If the Commission had the power to set up ex parte any person before it, while it is still seized of the dispute, it would also have the inherent power to also recall or reverse such an order or also restore the complaint on good cause being shown if it is dismissed for default. Well, the issue over here was dismissal in default. But my submission is if the provisions of the CPC are generally being adopted by the court while dealing with the cases under section 34, surely 151 CPC is also available to the court. Because the court, when it sees of the petition under section 34 or 37, issues the notices for which the CPC is followed. Dismisses the petition in default for which the CPC is
Okay.
also followed.
That's all?
That's all, my lord.
Okay, now how many, you are Mr. Rai, you are there?
Yes.
How much time will you take, Mr. Rai?
I'll take 15 minutes. I've in fact prepared a new 3-page.
Okay, others may then confide. Okay.
Because on the specific aspect of 34-4, which fell from Justice Vishwanathan, I can just take 10 minutes whenever my love's permit.
34.
Well, it just have a solution, I'm suggesting.
Okay, just sit among yourselves and then decide who's going to begin. Give a slip of papers to everybody. We'll call out the names by slip of papers.
Obliged.
The courtmaster will call out your names, call out names and then we start. I don't want everybody to be coming up and sitting up at the same time.